Hello, everyone. My name is Stephanie Bivens, and we're going to get started here in just a minute with our webinar about the Arizona Long-Term Care System, or ALTCS for short. We're pleased that you could join us today. I'm going to allow just a couple of more minutes here for folks to join us. All right, we've got a few more folks coming in here, so we'll give just another minute. And while we're doing that, I'll give you a little bit of information about us. So we're going to talk about the ALTCS program, which is Arizona Long-Term Care System. There's a lot of myths and a lot of mysteries out there about the ALTCS program. I am an estate planning, elder law, and special needs planning attorney, and I've been working in this space for 25 years now. So hopefully we're going to bust a lot of those myths and give you some information about the program, how people qualify, what benefits are available, and how it can help you to pay for long-term care. And a little bit of information about our firm. And if you have questions as we go along today, please feel free to use the question and answer feature on the webinar, or you can use the message feature, but maybe Q&A might be better. And I'll try and answer those questions as we go along. About our firm, as I mentioned, we handle estate planning, probate, trust administration, elder law, and special needs planning. So not only do we help clients qualify and apply for the ALTCS program, but we also draft estate planning documents like wills, powers of attorney, medical directives, and trusts. Somebody passes away, we assist the family with the transition, either through probate or trust administration. We do business entity formation. We practice all things elder law, which include long-term care planning, which we're going to talk about today, special needs planning, guardianships, conservatorships, are just a few of the things that we are honored to help our clients with. So what is ALTCS? ALTCS is the acronym. It stands for Arizona Long-Term Care System. ALTCS is actually a Medicaid program, not Medicare. So in Arizona, the Medicaid program is administered through ACCESS. ACCESS is short for Arizona Healthcare Cost Containment System. Most people are more familiar with that term than they are with ALTCS. ACCESS has a number of different health insurance programs. ALTCS is just one of those health insurance programs via ACCESS under our federal Medicaid rule or laws. It works like an HMO. If you've ever had HMO health insurance, you know, if you see a doctor that's on the list or is a participating provider, then the insurance pays for benefits. Same thing with ALTCS. In order to have ALTCS provide long-term care services, the ALTCS member needs to be living either at home, getting home health, or if they're not at home, living in their own independent setting, they need to be residing in an assisted living community, group home or adult care home, memory care or skilled nursing facility that participates in the ALTCS process. If you're living in an assisted living that is not in the ALTCS system, then ALTCS cannot pay. So one of the big myths that I frequently hear clients talk about is, well, if I go onto ALTCS, then are they going to pick where I have to live? And the answer is no. You pick where you're going to live, or you help your relative or loved one choose where they're going to live if they're not at home. But you have to choose among the options. Second big myth I hear all the time is, well, it's Medicaid. Generally, that means low income. So I'm thinking these places are not so great. Would I want to be living somewhere that ALTCS can pay? And the answer is yes. The communities and facilities that accept ALTCS are excellent. There's many really great care options out there, particularly in the memory care space. If somebody's living at home, and a lot of people don't realize that ALTCS can actually pay for home services, ALTCS generally will pay up to 40 hours a week of in-home help. So it's not 24 hours a day, 7 days a week, but it can be a significant benefit at home. How it works is you will contract with a regular home health company. That home health company, however, has to have a contract with Access. So again, you're dealing with an Access certified participating provider. You work directly with the client service coordinator or with that home health company to determine how many hours you're going to be receiving and when those hours during the week will be delivered to you at home. ALTCS is health insurance. So they're never going to put money in your bank account. It is not a cash benefit program. This is a health insurance program. So if you're on ALTCS getting home health, ALTCS is paying the home health company. If you're living in, let's say, memory care, and ALTCS is paying for the memory care, they are writing a check directly to the placement or the memory care community. So it works very similar to traditional health insurance, but there's many different rules that you have to qualify. You can't just go out and buy ALTCS benefits because it's an entitlement program. So we're going to cover today for single people what the medical income and resource or asset criteria is, the same criteria for married persons, what has to be disclosed during the application process, because that's where we see most people getting tripped up, is A, they don't understand the process or the rules, and then B, the application itself is so difficult, they get tripped up and that causes denials. Our contact information is on the screen as well. So we're going to start off with single people. What are the eligibility criteria? There's 3 criteria. All 3 have to be met: medical, income, and resources. Medical, and this is true for a single person or a married person. So the applicant has to meet medical eligibility criteria. The program uses something called a PASS or a pre-admission screening tool, and you have to get 60 points for an elderly individual or a physically disabled adult to qualify for ALTCS. You have to get 60 points on their scoring tool. So what are they looking at? They're looking at how much help does the applicant need with their activities of daily living. Things like dressing, bathing, grooming, transferring, ambulation, incontinence, behaviors. Are they aggressive? Are they, wandering? Cognitive impairments. Are they oriented to person, place, and time? Do they have short-term memory loss? And other diagnoses such as Parkinson's and epilepsy. A big myth out there is my mom has dementia, so we need ALTCS to pay for her care. Well, that all may be true, but if mom's dementia is not significantly impacting her own ability to perform her ADLs, let's say she's in the early stage of dementia, she may not meet medical criteria. You don't automatically meet medical criteria just because you have a diagnosis. It's always to what degree is that medical condition or diagnosis impacting the person's ability to perform their own ADLs. The more help you need, the better chance you're going to meet the medical criteria. In that process of demonstrating somebody's diagnosis and medical needs, ALTCS will look at the last 6 months of medical records. Medical records are really, really important. I cannot stress that enough. So in our planning, when we're helping clients go through this process, we want to make sure that during the last 6 months that there's a cognitive impairment, that individual has been seen by their neurologist, and we have current neurology records. If there's any other specialists that they need to see, that they have seen those specialists within that last 6 months. They've been to the hospital, they've been to the ER. Even if there's been falls and the fire department has come out and helped them at home and maybe not even transported them, but still had to come and help them with falls. all of that third-party diagnosis, documentation of the care they need will really go a long way towards helping for the passing on the medical criteria. This is the only subjective part of the whole application process. When we talk next about income and resources, the numbers are what the numbers are. So this is an area which shouldn't be overlooked because it is subjective based on the individual from ALTCS. They call them the assessor, the medical assessor. You know, they're only going to have as good as information as what is provided to them. So it's really, really important to answer questions honestly. It's a question evaluation. So they ask a series of questions about what the individual's needs are in these areas. So we always advise answer honestly, but be truthful about, you know, the level of need. Everybody likes to sugarcoat it. You know, if somebody asks you, how are you doing today? You're probably not likely to say, well, really, I'm struggling today, and here's why. This is a stranger to you. So they need to answer those questions in a fairly brutally honest fashion and not sugarcoat things. If the applicant has cognitive impairment, it's really important that a third party be present during that interview to be the truth teller, to make sure that the assessor is getting an accurate picture of what the real needs are that is going on, because obviously somebody who has cognitive impairment may not answer questions correctly, may forget their needs, may not be able to communicate in an accurate fashion. So those are some helpful hints on passing the medical criteria. At this point, medical is something that we always go through first before we start submitting the financial, before we submit an application, because we want to make sure that individual does in fact meet medical criteria. If they do, that medical determination is good for 6 months. So if we apply anytime during the next 6 months when the numbers are in the right position, then you don't have to repeat that medical assessment component. So let's talk about income eligibility. So for a single person, the income rules are pretty straightforward. If the applicant who is not married has less than $2,382 in, says 83, it's actually technically 82, dollars per month in gross monthly income from all combined sources therein, they meet medical criteria. So what is income? Typically for somebody who's not working, who's retired, that's going to be their Social Security, pension payment, any disability, or any irrevocable annuity payments that are coming out to them. Those are income. We're not talking about interest or dividend income. That generally isn't a factor once somebody's on ALTCS because they're not going to have a significant amount of assets that are generating income or interest dividend. So just think fixed income, Social Security, pension, those are the big two. So what if we do if the individual has more than $2,383 a month? A lot of people will hear the income limit and they're like, oh, we're over that, we can't get ALTCS. Well, that's not true. We just have to jump through another hoop. You can still meet income criteria if the income is over the fixed limit, but we just create something called an income-only trust. It's also commonly referred to as a Miller trust. It is a trust that does not preserve assets. That's a big myth I hear, is that I have too much in savings, so I need an income-only trust. Apples and oranges, income to assets. The income-only trust or Miller trust only solves the income problem. So if a single applicant, let's say, has $2,500 a month in combined Social Security and pension, they earn too much to just qualify without doing an income-only trust. But if they establish an income-only trust the month before or the month of application, it's done properly under federal and state law, income is properly directed into that account, then they're going to meet income criteria. There are, however, very strict rules on how this trust is set up and how this trust is administered during the lifetime of that ALTCS member. It's really, really important you work with an experienced elder law attorney on getting that trust document set up. It's not like a regular revocable trust. Again, it's created under federal law. So there's a lot of strict requirements that go along with that. One of the big issues that we see is if the ALTCS applicant's not competent and now an agent is acting under power of attorney for them and handling their financial matters, the power of attorney must specifically grant the agent authority to establish trusts, including an income-only trust under federal law. If we don't have a competent applicant and we have a power of attorney that does not specifically allow the agent to create trusts, we're going to have to go to court and get a conservator appointed with authority to establish this trust. So if you are ever thinking that you or someone you love or care about might need ALTCS benefits, it is critically important that they have a financial power of attorney that is reviewed by an elder law attorney to make sure you've got this kind of authority. Because once we start talking about applying for ALTCS benefits, we've got to make sure the authority under that power of attorney is very broad when we come to Medicaid planning, spend down planning, creating income only trusts and the like. And we'll touch on this a little bit more during the presentation. But just for purposes for right now, just know if a single applicant earns more than the base income limit, there's still a way they can meet income criteria to achieve ALTCS eligibility. It's called an income only trust. So let's talk about resource eligibility, or what I like to call the assets, right? This is what do you own in countable assets. For a single applicant, they can have no more than $2,000 in total countable assets, plus they can have any number of exempt assets. So what's countable? Countable generally is what you're going to think of as cash equivalent. So that's going to be money in the bank, checking, savings, CDs, in brokerage accounts, stocks, bonds, cash value in life insurance policies. People usually forget about that, but that is a countable asset. Any secondary properties that you own. So a primary residence is exempt. We'll talk about exempt assets in another slide here, but secondary properties like that extra cabin, the plot of land, right? That's going to be a countable asset. The first vehicle is exempt, but second vehicles, third vehicles are countable. Boats, cars, trailers, RVs, those are usually all countable over the first vehicle. Retirement accounts, IRAs, people usually think a retirement account is not countable because when you pull money out, it's subject to income tax, or if you're prior to age 72, could be subject to an early withdrawal penalty. Guess what? Because you have access to the money, even if there's an income tax or a penalty, it is countable under federal law. Cryptocurrencies, believe it or not, I have had several 85-year-olds have Bitcoin. That's been fun to document to the state. Cryptocurrencies, any kind of general investment, that's going to be a countable asset. You can only have $2,000 of that. So what is an exempt asset? Remember a minute ago, I said you can have your countable assets plus any number of exempt assets. This list of exempt assets is exempt whether somebody is single or married. So you can have one vehicle. Most expensive vehicle is exempt. Primary residence is exempt. Now there is a cap, it's about $560,000 or so. I've yet to have a client have, $1 million of equity in a piece of property that created an issue. So generally primary residence is exempt. Certain irrevocable prepaid funeral burial plans, your household goods, your personal effects, those are all exempt items. If you're under age 65 and disabled, there is something called a special needs trust we can use. Assets in a special needs trust are exempt. If you're over 65, that's not an option. Again, that's something that is carved out by federal law that is allowed. So let's say we've got a situation where we have a single person. Again, it's mom. She has dementia. She is now getting into the mid to later stages. She needs a lot of help with prompting, reminding, and cueing for her activities of daily living. She's also got some physical limitations, so she's a fall risk. She really needs somebody at the ready to help her make sure she's safely ambulating, getting up from the chair, using the restroom, toileting, showering. Plus, she needs prompting, reminding, and cueing to take her medications, meal preparations, getting dressed. Really, she's checking all the boxes of somebody who needs help. And mom's got more than $2,000. So what do? Well, one option is certainly just to pay her care expenses and her general living expenses. And eventually, you know, if mom has $50,000, it's going to go. It's going to be gone pretty quick. Cost of long-term care is very expensive. If you're not familiar with those costs, on average, we see people paying about $25 or so an hour for in-home home health. If somebody's living in assisted living, those costs are going to go anywhere from probably $3,500 on the low end to $6,500 or $7,000 a month on the high end. So long-term care is very expensive. Medicare has no long-term care benefit. So it's either on your pocket or a government program like ALTCS. So let's say the writing's on the wall, mom is likely going to outlive her money, right? ALTCS is here, it's the safety net. Eventually, if we just pay her bills, she's going to get down to $2,000. And then she can transition onto ALTCS and move from a private pay, meaning out of her income and her pocket exclusively, her savings, onto ALTCS. But gosh, wouldn't it be better if we did some planning ahead of time and had a planned, timed transition where we're still going to preserve and protect some of these assets for her? So what do we do to spend down? Spend down is a term of art where somebody who needs ALTCS has too much assets today, and we want to accelerate their financial eligibility. Well, we look to exempt assets. Maybe she needs a car. Maybe there's a mortgage on the house or a loan on the house that can be paid. Maybe she doesn't have her prepaid funeral and burial expenses covered ahead of time. Well, we can, you know, take care of that for her ahead of time. Maybe there are things she needs like dental work, or we pay off the credit card bills. There's lots of things that we can look to reposition our assets from accountable category, just money in her checking and her savings or her investment accounts, into things that are of benefit for her, but are on that exempt column. People always worry about estate, well, and gifting is one thing too. We'll talk about gifting in a little bit. Estate recovery and liens. So, you know, let's assume we've gotten mom spent down. She's going on to benefits. Everybody is concerned about, well, this sounds too good to be true, right? ALTCS is going to be paying for the rest of mom's life, the cost of her out-of-pocket care. We could be talking about hundreds of thousands of dollars worth of care being paid through the state via the ALTCS program, right? What's the catch? So most people have heard something about estate recovery and liens. Most people have heard myths about those programs. So here's the straight scoop. ALTCS has the right to be reimbursed after an ALTCS member dies from their probate or their probatable assets. So what does that mean? Probate in Arizona happens when someone dies and they have assets or accounts in their name alone. They die, there's no joint owner, there's no beneficiary designation on that account or that asset. It is now sitting in their estate. ALTCS has estate recovery. There's like super creditor. They're the first creditor to get paid through the probate estate. Well, if we just do some planning to avoid probate when that ALTCS member passes, now we've also defeated or avoided estate recovery. So for our clients, we always make sure we're looking at how are the assets and the accounts titled so that we are going to avoid probate. So maybe there's a transfer on death designation or a pay on death designation to that account if they have a checking account. If they still own a home, remember a home is an exempt asset. Maybe we can put a beneficiary deed on that house. So with proper planning, people really don't need to worry about estate recovery happening. Now, liens are something else. TEFRA liens are when Access gets to put a lien against an ALTCS recipient's interest in real estate during their lifetime. TEFRA liens may only be put on real estate if the ALTCS member is living and receiving care in a licensed skilled nursing facility for more than 90 days paid for by ALTCS. So most people on ALTCS are not in skilled nursing facilities. They're in memory care, assisted living, adult care homes, or at home. So sometimes by controlling placement, we can defeat a lien. There's also other things we can do to make sure that person doesn't have an interest in real estate any longer, just through planning. Also know that if the ALTCS member is married, and it's a huge concern by what we call the well spouse, right? The spouse who's in the house, which always sounds like Dr. Seuss to me. The spouse who's at home is always worried, I'm living in this house. Is the state going to put a lien on it? Is the state going to take it? And the answer is no. There is no estate recovery when there is a surviving spouse. So when the ALTCS member passes, if they're married, just because they are married and there's a surviving spouse, there's never going to be a lien and there's not going to be any estate recovery. That is sometimes the largest fear that people have, and kind of a reason why they may not be as interested in learning about ALTCS, because they have these fears. There's a lot of myths out there. Just know with planning, we can get around those concerns. So for married people, the rules are a little different, right? We're going to talk about the resource rules, but I'll also talk about the income eligibility rules. So for a married applicant, say husband and wife, let's pick on the husband. Let's say husband he's had a stroke. Unfortunately, he has significant impact, left side paralysis, cognitive impairment. He needs help with a lot of his activities of daily living. He's living in assisted living. He may or may not ever be able to come home, but the cost of assisted living is starting to keep the well spouse up at night, right? They're writing checks of $6,000 a month. How can they afford to do this? How is she going to continue to meet her every day, grocery bills, transportation, cell phone, just household expenses, right? If we can shift the cost of care from this couple privately to ALTCS, that's going to give her a whole lot of peace of mind. She doesn't need to be worried about going bankrupt due to the cost of long-term care, because ALTCS is going to pick it up for him. But what are the rules to qualify? So if his income is less than the single person limit, that $23.83 a month, we're in. We don't care how much income she has. If his is more than that, but they're combined, both spouses' incomes is not more than 2 times $23.83, then we're still fine. We don't need to do anything. And so that's $4,764, sorry about my math. But let's say this couple doesn't meet that Rubik's Cube, right? He's more than the single person limit, and their combined incomes is more than twice the single person income limit. We can still get him qualified. Again, we use the income only trust. So income is almost never a barrier. It's resources. So for a married couple, there are resource limits for both the applicant and the spouse. And the process by which ALTCS determines how much the well spouse can have in the form of countable assets and still qualify the Medicaid or the ALTCS applicant spouse for services and benefits is called the Community Spouse Resource Assessment, or the CSRA. So when we are doing advanced planning for couples, the goal is to make that CSRA as high as possible so that the well spouse can keep as much as possible in the form of countable assets. What ALTCS does is they look at all the assets the couple has, and it doesn't matter whether it's in his name or her name, jointly titled, or it's in a trust. And we get this question a lot. It doesn't matter if there's a prenuptial or a postnuptial agreement between the couple. Even if it says, honey, your expenses are yours and mine are mine, I'm not financially obligated to pay your expenses, that is not binding. This is related to ALTCS applications. This is a federal program. So these are federal rules, and under federal law, the assets of the couple, whether it's his, hers, joint, or even in a revocable trust, they're all looked at related to what this couple can own and what the applicant's spouse can own. So when are they looking at the assets? They are looking at the assets as of the month the spouse who is applying for benefits first meets medical criteria. So when we're doing pre-planning or advanced planning, if we think somebody's going to start needing care, but they really don't meet medical criteria now, there are some things we can do to potentially artificially inflate that resource number. So just know advanced planning can make a significant difference for some couples. So here's the process for getting the state to confirm how much can this married couple keep, right? And here are the rules. We first request the medical assessment or that private pre-admission screening, what we call the PASS, to confirm the spouse who's going to need long-term care meets medical criteria. That locks in the month. We look at all of the assets, how they're titled, what they are, their values as of that month, and you submit all those statements. And when I say all the statements, I mean all the statements, all the pages to the bank statement, not even the ones that have all that little fine print on it that don't have any bank balance numbers, all the pages, copies to titles of vehicles, copies of deeds, life insurance policies, absolutely everything there is has to be documented right directly from the financial institution holding those assets or accounts. We get those statements and then those are submitted. ALTCS looks at the assets. They're going to divide them into two columns. The exempt assets, you get to keep those. So the house, the car, let's say you had a burial policy, those are over here in the exempt, but everything else that is countable, the cash equivalents, ALTCS looks at that, or Access looks at that. The spouse can keep half of that, except there is a maximum and a minimum. So the most any married couple can keep in the form of countable assets is $130,380. So let's say there was $500,000 in cash assets as of the month the applicant spouse meets medical criteria. The well spouse doesn't get to keep $250,000. The most would be $130,380. Makes sense? That's the cap. And that's the same for any state because this is based on federal law. There's also a minimum. At a minimum, the well spouse gets to keep $26,076. So let's say the couple had $20,000 in the bank when the applicant spouse first needs criteria. They're not going to have to spend down to $10,000, which would be half of the 20, because at a minimum, this couple can have $26,076. So no spend down, right? They're already below the minimum a married couple can have. So every single married applicant applying for ALTCS has a unique CSRA. It's dependent upon what they owned, how it was titled, its value as of the month we meet medical criteria. So ALTCS is going to tell you, if you call ALTCS, let's say somebody in the hospital or in assisted living said, I'm going to help you with that application, or you just call it in yourself, and you have too much in assets, what's going to happen is ALTCS is just going to tell you, call us back when you have less than $2,000 for a single person, right? Or if they process the resource assessment, they're going to say, well, come back and apply when your countable assets are at this number. They're not going to give you advice necessarily on how to more proactively preserve assets in the spend down process. If you have excess countable assets, that's our job. So again, spend down, consult with your attorney. Don't do this alone. ALTCS planning is not a DIY area. There are some things you can do DIY to save a little bit of money. ALTCS is not one of them. Trust me on that. So potential strategies, just in general, are converting countable assets to exempt assets. Maybe you don't have a prepaid funeral and burial plan. It makes sense to have that, to pay for those costs ahead of time. Has to be done right. You need advice on that. Maybe you have an old vehicle and you want to upgrade the vehicle because the spouse is still driving the vehicle, right? Pay down debt. We look at credit cards, medical expenses, loans on vehicles, mortgages on homes. Anytime we are spending down, remember qualified monies like retirement accounts, they count. So sometimes we have to pull money out of retirement accounts to spend down. Well, that's going to create an income tax obligation. So we always have to weigh the cost of the spend down if there's going to be income tax consequences to the benefit that ALTCS is going to be providing. Make sure that, you know, money spent is going to be smart. You can pay for care costs, you can purchase items, goods, services for the benefit of the spouse or the applicant. And then we will often look at whether gifts and transfers of assets make sense for either single or married persons. That is a very, very unique area. There's lots of rules. You can't just give away money and get on the program. We'll talk about what those rules are here in a couple of slides. There has to be legal authority to make gifts. People get into trouble. If you're giving away your own money, you can do that. But if you're acting as agent under power of attorney for a mom, you can't give away her money. Even if the power of attorney says you can do anything for mom that mom could do, that's not enough. The power of attorney has to specifically grant you the authority to make gifts for Medicaid planning or gifts for long-term care planning. Just gifts for tax planning, this isn't tax planning. This is a different purpose. And if there's no gifting authority, your hands are going to be tied. So we'd have to go to court, right? So again, durable financial power of attorney created by an elder law attorney who is familiar with these issues and these planning techniques is really, really important. So you want to make sure that if you're acting as agent and you're engaging in long-term care planning, applying for benefits for someone, make sure you have an elder law attorney review that power of attorney, because you don't want to be accused of breaching your duties and financial exploitation of a vulnerable adult. Theft, fraud, or worse can happen. So gifting and transfers of assets is just an area, just trust me, don't do it without legal advice. You can get into big trouble. So income eligibility for married persons, we talked about this before. If the applicant's income is less than the 2383, we're in. If the total assets are less than twice that, the 4766, we're in. If it doesn't meet that criteria, we can do an income only trust for the applicant's spouse. But again, if the applicant's spouse is not competent to sign the trust, we have to have an agent under power of attorney with correct authority in that power of attorney. See your elder law attorney, make sure you've got the right authority. So what does the application process look like for a married person? And here's where a lot of people get tripped up. It takes a long time. So you don't want to wait until you're just out of assets and you don't have any money to pay for care, because this application process can take 6 months. And here's why. We want to get the medical assessment done. We lock that in. Then we have to get the CSRA completed, the community spouse. We need to know what number are we shooting for, right? If we have more than that number, we have to reposition the assets, pay the bills, buy exempt assets, engage in this spend down plan, right? Until the applicant is at their limit. Then we have to prepare for all of the disclosures. You would be shocked to see how much paperwork needs to be submitted to ALTCS. For a single applicant, it's everything the applicant owns in that month, right? Not as burdensome. For a married couple, let's say they assess the medical assessment this month in May, and the spend down is going to take 3 months, and then the application is submitted in August. ALTCS will have seen all the financial records of May. When you go to apply in August, let's say there was a $100,000 spend down, we literally have to show every single financial transaction that occurred from May to August. All the bank statements, all the receipts for anything that was purchased of more than $500, they may actually ask us for, believe it or not, even if it's care expenses, right? We're paying the adult care home or the memory care community, right? We may have to have the invoice to substantiate the dollar amount that was paid. So it is a record-keeping nightmare. You have to be sure you keep all of your records, all of your canceled checks, all of your credit card statements. That is going to show the complete financial picture from the resource assessment month to date of application month. Guess what? They have a right to actually ask for information that occurred in the 5 years before application. ALTCS uses a program and that will screen somebody's financial history, financial transaction history. And we never know which applications are going to get screened. But it is possible that in the application process, you could get a request for information for something that happened 3 years ago. 3 years ago, why was there a difference in the beginning and the ending balance of an account? Well, we have to be prepared within 10 days to explain that. So we really have to get a lot of financial information prepared before we even apply. Once we've got it all put together, then we call in the ALTCS application. The application process itself, under their own rules, they're supposed to approve or deny an application within 45 days. Right now, that's just not happening, usually 2 to 3 months, depending on the case. Estate recovery and liens, we talked about this before, but because it is such a huge concern, we're going to touch on it on a second slide here. For married couples, again, we have a spouse. We always leave the spouse on the account. So if the Medicaid spouse passes away first, we have a joint owner, we have a surviving spouse, there's no estate recovery. And again, the lien is going to have to be released if the member had a lien put on their interest in the home. Usually with planning with married couples, I will tell you there is no transfer penalty. I'll talk about transfer penalties in a moment between spouses. And so in the rules, to get one spouse qualified, we basically have to put all of the assets in the name of the well spouse, because we have to have less than $2,000 in the name of the Medicaid married applicant spouse. So we're basically going to shift everything in, because the rules require we do that, into the name of the well spouse. We oftentimes move the 50% of the home that is owned by the spouse who's going to be on ALTCS into the name of the well spouse as well. Obviously, we're making a gift of assets. We have to have authority to do it. There's a lot of legal considerations. Don't just go out and DIY this one. It's one of those do not try this at home alone warnings. But that will also defeat lien. And then in a married situation, we want to make sure we update the estate plan of the well spouse, because if we leave a will in place that says, if the well spouse passes first, everything goes back to the Medicaid spouse, well, now they're definitely going to have more than $2,000. They'll get kicked off of the program. We see this happen multiple times a year. This happens when people don't work with counsel and get onto ALTCS, and they don't realize, they need to plan for all of the contingencies, not just when somebody gets onto ALTCS, but what can happen after that. So here's mandatory disclosures, whether you're single or married. And remember a minute ago, I said, you will not believe the amount of documentation that is now required to successfully navigate the application process to an approval stage. If any real estate was sold in the 5 years prior to application, we now have to provide a copy of the settlement statement, proof of where the net proceeds were deposited, and then the expenditure of those monies all the way from the date of sale through present. You can imagine how difficult that can be. Invoices, bills paid, copies of the bank statements. So this is, just know, if you've sold a house and you may ever need ALTCS, keep all of those records, keep all of your financial records, all of your large receipts, bills, credit card statements, everything. Don't shred that stuff because we may need it. If there were any transfers or gifts made, so I'm going to do a little myth busting here for you. Most people have heard something about a 5-year look back period or a 5-year transfer penalty period. And usually kind of these myths get blended together. So here is the real deal. When you apply to ALTCS, they ask, have you gifted or transferred anything for less than fair market value in the preceding 5 years or 60 months? So if you gave $10,000 to a grandchild 4 years ago before you apply for ALTCS, you've got to mark yes. And then you're going to have to explain what you did, right? you're not necessarily ineligible for 5 years. That's the 5 years is just the window or the look back period where you have to disclose gifts or transfers. The penalty period, or the amount of time you're not eligible for ALTCS because of the gift, depends on the size of the gift. So here in Maricopa County, you'll love this number, which is right here. For every, let me get my little spotlight here. For every $7,204.78 that you gave away, there's 1 month of penalty. The penalty does not start running from when you gave the money away. The penalty begins from when you apply to ALTCS. You otherwise would have been approved, but for the transfer. So on the $10,000 gift to the granddaughter, right, for her wedding, that would create, you take 10,000 divided by 7204, you get 1 point something months. That will create a 1 point something month penalty period beginning the first month of application. Well, the application probably isn't going to get approved for 3 months. Penalty has run by the time you're approved, really no negative. But what if that gift was $100,000? That's going to create a multi-year transfer penalty. So oftentimes we work with clients who made transfers either because they thought it was the smart thing to do, somebody told them to do it to qualify for ALTCS, or it's the gift. You know, we just do stuff in families, wedding gifts, you know, birthday gifts, or a child is, you know, having a tough time and you help them out financially, right? We just do this in families. ALTCS will presume the gift was made with the intention to reduce your assets and qualify. They will attempt to impose a penalty. So we have to deal with those penalties. We can give the assets back, we can rebut the presumption, or we can deal with it mathematically and plan around it. Just know we have to, if there's a gift, you have to disclose it or it's fraud. You have to show all sides of the transaction, your side as the giver and the recipient's side, their bank statement, their statement of facts that they got it. So it's a lot of money. And then the other issue we see people do is this commingling, mandatory disclosures. So if you take money from mom, because you think this is the easy way to go, you take money from mom's account, you put it into your account, and then you just pay all of mom's bills from your account. Don't do that, because it looks like mom made a gift to you. And now we have to substantiate every single penny that mom gave you to prove it was expended for mom. We have a case right now where mom and son co-owned a house. It got sold. 100% of the net proceeds were deposited ultimately into son's account. He has used well more than half of that money paying for her care for the last 3 years. Now she needs ALTCS, and ALTCS is saying because they didn't have a written agreement in place before he started making those payments back, it's really not it's just creating a huge issue. So just don't move money from parents' account into your account and pay bills. Just pay bills directly from mom and dad's account. That's just the best way to handle this from a fiduciary standpoint as well. It's a lot of record keeping. That's usually where people get into trouble. All right, let's see if I can get to the next page here. All right, so issues to watch for: out-of-state property, that's going to be accountable. Business interests, dealing with LLCs, rental properties, you definitely need legal counsel. That's hard to deal with ALTCS. Is there a comprehensive power of attorney in place? If not, you know, run, don't walk to your elder law attorney's office. See if we can get it, while there's still a window of capacity here, get an updated, very robust, durable financial power of attorney. If this person is no longer competent to be signing new powers of attorney or engaging in these kinds of asset protection planning strategies, you know, we may need court involvement through conservatorship, guardianship. These are just all issues to be aware of. If there's been a sale of real property in the last 5 years, you really do need to get those records, have somebody look at the closing statement, help you trace the funds. Absolutely don't pay bills for somebody else out of your account and think that's going to go well in the course of an ALTCS application process. That's just not a good move. You want to keep everything separate to the extent of, if you're an adult child and you run to Target and you're shopping for yourself and a parent, put your stuff on the little conveyor checkout belt, put a divider, put your parents' stuff on, pay your stuff with your money, pay your parents' stuff with their accounts or their credit, their debit card, checking card or credit card. And I'm assuming when I say that, you have durable financial power of attorney and legal authority to be using their accounts and their assets for their benefit. So that is all of the slides. We have a lot of helpful information, frequently asked questions on our website. A lot of the income, asset criteria, financial eligibility criteria is all on our website. Let me see if anybody's got, I don't see any open questions or anything in the chat. I'll kind of follow up here with a few other things that people need to know about ALTCS. First, it's a fantastic program. It really is great for people who cannot afford long-term care. This is the best way to get the care they need at a high quality in a way that does not bankrupt them. Adult kids often come in and they say, I've been paying for mom and dad's general household expenses because my parents have very limited savings or limited income. They really can't afford it. But this is beyond me now, right? They need home health or they need higher levels of care. This can really help the entire family out. For married couples, this is how the well spouse sleeps at night. You don't have to worry about going bankrupt. And you don't have to have, less than $100,000 as a married couple to take advantage of this. We've worked with clients who have hundreds of thousands of dollars in assets that we are able to protect. There are lots of planning techniques, one of which, and we don't even have it on the slide, is a Medicaid compliant annuity. It's very, very tricky to set up. It's based on federal and state law, so we don't put anything in writing out there because we don't want anybody to go out and do it the wrong way. If it's set up incorrectly, it's a permanent problem and creates a transfer penalty. We don't have legal recourse to fix it. But if it's done right, we can save a lot of money. Almost all of the cash assets for a married couple can be saved through the use of an appropriate Medicaid compliant annuity. The best thing you can do is, if long-term care is something you think will be on the horizon, either for yourself or for a loved one, and you're not sure it's affordable, right? You'll have enough of income or assets to pay for that for any significant period of time. The number one thing we can do on a pre-planning is to get in, meet with an elder law attorney like us. We look through everything and we can build into your estate plan in the power of attorney or in a trust. There are things we can do to artificially inflate assets sometimes, so you can actually keep more real dollars in the bank later. There are things that we can do to put into the power of attorney to preserve the ability to create trusts, to make gifts, transfers of assets, if that would be in the person's best interest, to actually preserve gifts and transfer, to preserve assets. Again, pre-planning allows us to get a game plan in place, right? I always say we like to plan for the worst and hope for the best. So if we don't need long-term care, you don't need ALTCS, that's great. But if you did, you're not going to be in a panic situation. But what if you are in what we call crisis planning, right? The care need has triggered. There's been a sudden onset. Nobody saw it coming. Something like a car accident, a major stroke, a very sudden onset of a progressive illness. And we need care and we need it now. And you're writing checks and you can run the math and you're going to run out. Well, why just wait to go bankrupt and then apply? right? If we can make sure that some of these things that can be taken care of ahead of time are taken care of, and we can have a smooth transition from private pay onto ALTCS and help in that care planning, whether we start at home or we start somewhere else. It's just, you know, we can still preserve a lot doing crisis planning. I will tell you, with the crisis planning that we do, people who go it alone with a system oftentimes get denied, but the application process takes so long, they're not denied for 4 to 6 months. Well, there's been a lot of drama, a lot of angst, and a lot of financial dissipation during that. And then you have to start over, only you don't even know where to start over, because all they're going to tell you is your application is denied. So it's far better, even in a crisis situation, to sit down with a very experienced elder law attorney and learn what you really need to know at that point in time. So you've got a game plan. Whether or not you're going to preserve a little bit of assets or a lot of assets, it's all about care, right? Money comes second, care comes first. At least that's how we approach it with our clients. So we want to make sure that, you know, people are not going without the care they need because they're worried about the cost of care. We've seen that. We've seen people who needed home health way before they were willing, and now they fall, they have a hip fracture, and they may never be able to come back home. Well, you know, if they'd had help, maybe that fall wouldn't have happened, right? So we're all about quality of care, families making decisions together, the people who need to be the advocates for the disabled or the older adult who needs care, having the right legal tools in place and getting the best information at time of need, either pre-planning and then also when that care need happens, what we call crisis planning, again, when we're starting to write the checks, we're about to start writing the checks for care, so that you can make the best decisions to achieve optimal personal, medical, and financial outcome. The ALTCS program can be a great resource as part of that puzzle of achieving best personal, medical, and financial outcomes. But the program is extraordinarily difficult to navigate if you're not familiar with it. I will tell you, people in hospitals, social workers in care communities, they mean well and they say, oh, I'll help you with that. The problem is they don't have the legal knowledge and the legal background to understand the federal and the state laws and the rules about how you preserve assets, what legal authority you need in order to proceed, to get you through the whole entire process. This is not what they do on a daily basis, right? You want somebody who does this on a daily basis to work with you on the ALTCS program. We meet with clients, they come in, all they need is a consultation and they're good to go, right? They're ready. There's not a lot of planning. They just need to know what they're going to have to do and what to expect and how to do it. More often, however, they come in with a few questions. They have 2 questions. They really don't even know what they need to ask. And we're able to shepherd them through the entire process. So just know we're here to help. Long-term care is, you know, something that a lot of people are going to be facing, a lot of families are facing, and we're here to help with that. Whether ALTCS makes sense or not, we can at least pre-screen you, see if this is a program that makes sense. For most people, it does. If they're worried about running out of cash assets, and a lot of people we work with end up saving most of their assets simply by engaging in ALTCS or long-term care planning with an elder law attorney. We see very, very different outcomes for people who don't get the right legal advice going through the process. So we are close on time. I'm going to see if anybody in our group today has any questions. Feel free to put it up in the Q&A or in the chat if you would like. You know, again, we're here to help you. ALTCS it's a huge program to understand, but the benefits are fantastic. You can be at home, getting home services. And by the way, most people at home end up paying almost nothing for care. So it can be a huge benefit, particularly for married couples where the wife can do the evenings and the weekends, but you know, the fatigue is setting in, or the husband, whoever is the caregiver spouse. If we can get somebody in there 25 to 30 hours a week at no out-of-pocket cost to this couple, now we may be able to keep somebody at home much longer, which is oftentimes the goal, right? Because our caregiver is not getting so drained himself or herself personally. You know, paying for care, once somebody's on ALTCS, only their income is going to have to be paid towards the cost of their care. The spouse doesn't have to pay anything out of their income towards the cost of care. So Yvonne put a good question here in the chat. I may have missed this point, but are your choices limited as to care facility if you're on ALTCS? Yes, Joyce, the choices are limited, but there are lots of choices. So when you're not at home and you're on ALTCS, let's say in an adult care home, memory care, or skilled nursing, or an assisted living community, where you're living has to have a contract with ALTCS. They have to be a participating provider. But there are lots of really good, high quality participating providers. So you may not be able to go to, you know, the 5-star luxury resort on assisted living because they may not have an ALTCS contract, but there are some really, really great communities. We have yet to run into a situation where somebody couldn't find a great placement to meet their needs on ALTCS. So that's a really good question, Yvonne. Thank you. Any last minute questions? We've got about 1 minute or so left. I really appreciate everybody's time today. Hopefully we busted a few myths. You got a few good nuggets of information. Just know ALTCS planning, I always equate it to snowflakes. You know, every case kind of has some similarities, but each individual circumstance is different. It's based on marital status, actual care needs now, likely care needs in the future, income, assets, type of assets, goals and personal objectives. So although the rules are the rules, how you get onto the program in the best way for you is really going to be an individualized plan. So with that, we'll go ahead and end our workshop today. Thank you so much for everybody who took the time to attend, and we'll see you next time. Thank you.